We heard about how the Taiwan situation in terms of the setting up of tariffs in Taiwan. And these topics are more interesting in terms of, we understand earlier because of the Copyright Act amendment in Taiwan. So earlier in Taiwan, there was there are a lot of discussion relating to this topic. I think the controversy or the interesting part of this topic is people always think that there will be some different or conflicting interests. But in fact, I can say these interests are, although they are different, but they need to be balanced. In fact, copyright legislation developed over 100 years is for the purpose to ensure creation so that we can safeguard the creator's interests out of their creative efforts. On the other hand, as the law is developing, limitations, exceptions are being introduced in the copyright legislation to allow free dissemination of copyrighted work to the public, so that allow public to be able to exploit the copyrighted work when it is expired of protection, or when there is some limitation before it is expired, there is some way they can use it without paying the royalty or getting the authorizations from the relevant right holders. However, many limitations on the rights will adversely affect the promotion of creativity and may work against the legislative purpose that copyright law intend to encourage authors to realize creative ideas. So it is very important when copyright legislation is reviewed, or in development of copyright legislation, there must be a balance of interest between right holders and the public, so that it will help the creative industry to develop on one hand, and to allow public to be able to make use of copyright work in further to develop the creative industry. So I'm so happy to moderate these sessions, and we have very interesting combinations of speakers in this panel. We have Sophie Chen from TIPO. We'll be talking more about the Taiwan situation or from the government perspective. We have very experienced. We heard Katie telling us he's been in this industry for many years, and he has been helping to the development of many copyright legislation in these regions in particular. So his experience is very rich to tell us about what are the developments of the limitation exceptions, and also in a recent situation, because of online exploitation of work, it's become controversy as to what shall all these government to consider to open up more limitation, or should be limit more. I think that's a very controversial issues. And also we earlier heard about the Australian perspective in terms of licensing, but also Australia, interestingly, also recently have been reviewed on the copyright legislation. And one of the topic was in discussion is whether more of the limitations should be expanded in Australia. So we can hear more from Mr. Morris about the situation in Australia. Last but not least, we have Professor Huang from College of Law, National Taiwan University. So he will be talking about on an academic perspective about how he views about the development of limitation exceptions, especially on the definition of fair use. I think this is one of the controversial topic that's recently being discussed. Without delay, I first introduce Ms. Sophie Chen from Section Chief of Copyright Division of TIPO, Taiwan.
Okay, thank you, Ben, and good afternoon, ladies and gentlemen, and our distinguished guests from Australia, Japan, and Hong Kong and Singapore. I'm Sophie Chen from TIPO, and it's my privilege to share with you some points of view of limitations and exceptions to copyright in Taiwan. Oops. Yes. So firstly, I'd like to give you a brief introduction of limitations we can call LNEs in our Copyright Act first. And I'll share with you some profiles about our amending text, just like Ben just mentioned so far, including inquiries raising from our industries in public hearings and the responses and the future plan of TIPO. The current provisions, as you may figure out from this slide, not only limitations and the exceptions are included in Article 44 to 63 in our Copyright Act, but also we have a fair use provision in Copyright Act, Article 65, which means that whenever a specific use couldn't fall within the scope or the requirement in the LNEs, it can still be examined by the 4 factors as shown in this slide to see if it falls within the scope of fair use. So it is very flexible for the digital era. And you may tell from this slide that we have some limitation and exceptions, just for example, for administrative purposes, for judicial processing purposes, and for educational purposes. And some LE limitations for libraries and archives, or for the purpose of information circulation, or for the nonprofit activities, and for the disabled, just like the amendment just passed this January in cooperation with the Marrakesh Treaty of WIPO. And the last, the personal use, and this is just for example, this is not exhausted. So, speaking of the review of Copyright Act, as we may know that it is a national trend of a national exercise to amend, to review or reform our Copyright Act in each country. As you may see that in United States, in Japan, in Australia, we all have some amendment proposed to see that our Copyright Act could be in response to the development of digital technology. As you may see, that with the technology, we have more and more user-generated content are created, and people can access to copyrighted works much more easier and faster than ever. So, in response of such technology, TIPO has introduced a public transmission right, which is an exclusive right for the right holders to circulate their works on the internet. However, we didn't adding new exceptions or limitation at that time for some cautious considerations, and we'd like to see for a certain period of time to see the practice. However, the competent authority keeps such thought in mind. How should the knowledge be disseminated, be accessed online? How to balance the interests between the public and the right holders? And that is the main theme that we always thinking and considering. And we initiate the review since 2008, and after 3 years effort and 47 consultation meetings, as you may figure out from our website, we propose a first version of amendment this April. And I have to please be noted that this presentation, the limitations and exceptions mentioned in this presentation are limited in those who are to respond to the digital technology. So maybe such as non-profit activities we are not discussing today. And in this amendment, we introduce 4 new types of exceptions and limitations, including distance education, fair use for libraries and archives, and the incidental use and the parody. So we'll mention it one by one. Distance education has become more and more popular in these years, and our Ministry of Education has been keen to popularize distance education, such as MOOCs. You may know that as the massive open online courses. So in response to their suggestion, we provide in our amendment in this April, we provide that teachers at registered schools, as you may see here, of all levels or at any nonprofit organizations could offer copyrighted works to their students sitting in the classroom while teaching. And the student who accepts this course at different place, but at the same time could also be permissible. So this is the first track. We made it a fair use provision. As to those that accept the courses asynchronously, which means we access the course at a different place and at a different time. We made it a statutory license, which means the users, the teachers, or the schools and organizations are remunerated. So this is our first version of the distance education. However, our right holder expressed their concerns regarding the scope of the non-profit organization and the students who could access such courses. And according to their opinion, the scope is too vague and is not that clear and may be lead to misuse of this article. So after further discussion, we have proposed an alternative which could be discussed with our right holders on September 16th later. In short, in this version, we shrink the range of eligible users and the recipients. That is to say, in this version, only schools registers of all levels and the teachers at these schools could offer materials, could offer copyrighted works to the student who is registered normally to these schools. However, these students could accept the courses whenever they are sitting in the classroom face-to-face teaching, or they could choose any time, any place they want to accept the course. But the range of the recipients is quite limited. This is the fair use. On the other hand, for the courses like MOOCs, like the massive open online course, we think that since the recipients could not be specific, could not be limited, it would put too much effect on the right holder's interest. So we think it could be the statutory license, which means that the users, the schools, and the teachers still should be remunerated, but they are permitted to use this works. However, they have to pay. And as to the remunerations, in our proposal, we think it's better for the right holders and the users to negotiate. And next, we move to the libraries and archives. In our current Copyright Act, libraries, museums, other cultural institutions are permitted to reproduce the books in its collection, or to reproduce works out of print and acquired, and the books acquired through the inter-library cooperation. This is in our current Copyright Act. And in our amendment this April, we provide further exceptions for these libraries, museums, and cultural institutions to offer online transmission, but it is exclusively on the premises of these institutions. And in this slide, this part, we took reference of Japan and Korean's Copyright Act. We authorized the National Central Library to reproduce materials deposited in their collection or any materials posted by government agencies or public juristic person, not only for the digital archives, but also they could offer online transmission exclusively in the library. However, please be noted that we have set some requirement for the cultural institutions and the National Central Library when they offer the online transmission for their patrons to browsing these materials in the premises. They have to they have to provide some technical measures to prevent the users from copying or using these materials. And so this is to say that the users could only browsing these materials and no other use can be made. We have no strong objections against the use of libraries and archives. But the next two, we have gained a lot of strong objections. The first one is incidental use, which you may see in this slide. Whenever you are creating a work by means of video recording, by photography, or by sound recording, and accidentally you have reproduced other people's copyrighted materials into your work, and the work is not the main target, and the third requirement is that it's quite difficult to separate the work that you used and your own work. In such kind of condition, our amendment in April permit people to incorporate other people's copyrighted materials into their works. But as I have mentioned, this has aroused many objections from our right holders and industries. The second one is the parody. Parody, as I have Googled on the internet, a definition roughly is that a humorous use of an existing song, play, or writing which gives farcical and ironic meaning. And the list maybe involves public interest of freedom of speech and the freedom of expression. However, they are currently limited legislation so far. And in this legislation, we could not find a clear definition to describe this kind of use specifically. However, since this kind of use is quite common in today's society, so we still consider to put this, make it more clearly and put this into our exceptions and limitations. And again, this has gained a lot of strong objections from our right holders. So for further discussion of TIPO, since incidental use and parody has right now, since they have no clear articles regarding this kind of use, such use could be examined by judges according to our Article 65, and they can be examined if they fulfill the 4 factors provided by this Article 65, they may be decided to be fair use. Since these two kind of use could be examined by Article 65 right now, so we are considering maybe we'll maintain the current provision. That means maybe we maybe not add these 2 provisions in our exceptions and limitations. And prospect, as maybe it's a cliche in copyright amendment, it's quite difficult to make a balance of public interest and copyright holders' interest. And we are still working on, and we are planning to have more consultation meetings with industries and the right holders and the scholars and some experts in the future. And the review will still go on. And that's my presentation. Thank you.